my gut tells me I wouldn't be surprised if they come out with the proposed rule that says we want to update just to keep up the pace with inflation, and that would probably be somewhere around 3 million. So it would not shock me to see a proposed rule come out from the SEC that increases the limits from the current $1 million to the $3 million, maybe 2.5. And again, I think that's just in conjunction with this expansion, and hopefully by then, before that rule becomes final, we'll have a few certification programs. So somebody who wants to go take the exam. Welcome back to Real Estate Syndicator Live episode 14. And today we're going to do a deep dive on the accredited investor sort of current state of affairs, and then also talk a little bit about some specifics on accredited investors, because a lot of confusion that has been coming out. We actually got a lot of questions, which is unusual pre-live. And so we're going to answer some of those questions. But we talked a little bit about this last week, but I obviously recognize that not everybody's on. So if you were on last week, it might be, the first part might be a little bit repetitive, but let's start with let's start from the beginning. So I'm going to do a deep dive. So this might be a little bit longer than usual, but that's good. The accredited investor, well, let's start with the beginning and make sure nobody's left behind. So the definition right now of an accredited investor, at least for individuals, is anyone who has $1 million in net worth, excluding their primary residence, or has earned $200,000 the last 2 years with a reasonable expectation of earning $200,000 this year. And if you're combining, which you can, with your spouse, that number will go up to 300,000. Now, the last major update, not considered the one from last year, was when they added that little caveat of without primary residence. And I think that was back in, in the late 2000s, because as I always joke, everyone in California was becoming an accredited investor because the value of their home was going through the roof. And so they decided to add a little twist where not only did you have to have $1 million in net worth, but it had to exclude your primary residence. An important thing to remember is that definition of an accredited investor came out in 1982. So that's when it originally came out on the definition. And since then, for the last, what is that, 40 years, there's always been this debate, which I know you guys are aware of like, is the financial wherewithal, the financial background, is that really the best measure to determine whether somebody can come in as into one of these, a private placement, right? Because as we all know, under a 506, most investors, either a 506C or a 506B even, most of them, you've got to be accredited. There's obviously some exemptions that we'll talk about today, but there's always been this debate because we all know people who have millions and millions and millions and millions and millions of dollars and are just the dumbest people in the room. And we also know people who have modest means who are smarter than everybody here combined. So there's always been this debate as to whether the financial wherewithal really is the right mechanism to which, to allow people to invest or not. And finally, last year, the SEC came out and basically kind of, I think, acquiesced to that notion and said, yeah, let's expand the definition. Let's expand the definition to not only include financial metrics, but let's set up a certification program where people can actually study for an exam, pass an exam, and get certified by someone. And we'll get to that someone in a second. And then have, with that certification, be now considered an accredited investor. So now if you don't have the net worth or income, you can study a little bit and pass the test, and now you're going to become accredited. And that kind of makes sense because, if you pass the exam, that means, at least, you've done some work there that you can protect yourself. I don't know if it's the unfortunate thing or not, but when the rule passed, the concept, so this is a rule that actually passed. This is not a proposed rule. This is not an idea. This is an actual rule that's in the books. But the challenge is that they didn't get around to giving us all the details. And so at the time the rule got released, there was no specific certification programs out there. In fact, there was nobody who was actually certified. The SEC has to certify these particular entities to give the exams and give them authority to give the exam. And that process hadn't begun, or nobody knew what the criteria would be for somebody to qualify as a certification program. One that probably comes to mind is all these sort of Kaplan, me being a lawyer, I remember studying for the bar. You can always, you take these courses through these companies. And if you go to medical school, there's other ones that you can take, and they administer the training and the courses. So my guess is it's going to be something like that. But at the time, they didn't have any of those certification programs over, and they just said, hey, it's going to come it's going to be released down the road. And so our thinking was, hey, over the next couple of months or a couple of quarters or the next 6 months or whatever within the next year, the SEC would slowly release some certifications, and now people can go actually sign up and take an exam and pass a course or something. The only ones that they actually approved right on the spot, which was based on an exam, are investment advisors. So registered investment advisors who specifically had a Series 7 or a Series 65 or a Series 82, they immediately became accredited investors. So you have a bunch of individuals who previously from that rule were not accredited because they didn't have the net worth or the liquidity, but because they were, Series 7 license holders, they became accredited. And we just started waiting and waiting and waiting and waiting, and it never came. And it still hasn't come to this day. So as of today, as it stands today, the only certification programs we have is still those that are through the, registered investment advisory form, which, as you guys know, is not, if you're an investment advisor, that's something of interest to you, that's fine. But if you're just a passive investor and you want to become accredited, it's very difficult. Not that it's very difficult, it just doesn't make a ton of sense to go that route, because not only do you have to study for an exam and pass an exam, you then have to actually register as an investment advisor with your particular state, which isn't easy. And that's why, I think it's on I know it's on the Facebook group. I did I did a step-by-step guide, so to speak, of how to get a Series 65 license, because that's the easiest of all the three to get. You don't need a sponsoring entity. You can just go do it. And so I did a little bit of a checklist, but it's not easy. It's the easiest, but it's not necessarily easy. And so that's kind of the current state of affairs with the expansion of the accredited investor rule. And then we got a little bit of a surprise, because the small business committee from the SEC, I forget the name, it's called like the Small Business Capital Formation. I forget the name of the subcommittee, but they're the ones that advise the commission as to what their thoughts are regarding all of these policies. And they've been in favor of expanding this definition for years now. And they were in favor of the expansion that happened, the certification, and they continue to push the SEC to expand that and get around to giving us the freaking certification programs. But literally, I remember in February, they had their annual meeting and they do a report, and that's available online. You can just Google it, and there's a report out there. And again, they state that they are in favor of this expansion of the accredited definition, investor definition. And then we got hit with that, a lot of articles that went around, but essentially we got hit by the schedule that the SEC has, sort of their agenda for the whatever the summer or spring or whatever they call it. And on that agenda was the proposal to address the definition of accredited investor. And all of these rumors started going around. There was an article by Bloomberg, and everybody kind of picked up on the article that there was rumors that they were going to increase the accredited investor definition from a current $1 million in net worth, excluding primary residence, all the way to 10 million. So at first glance, I was like, well, that doesn't, what's going on here? Because on the one hand, they're trying to expand the definition, make it easier for people to be accredited. But on the other hand, they're talking about increasing the accredited investor definition up to 10 million, which would obviously, shrink that thing, majorly. And the more I thought about this, I've come to the conclusion, and this is just kind of my thoughts on the area. And this is not, I don't have any inside info. I don't have any contacts at the SEC. They know my brother-in-law is not a part of this commission. But if you realize or remember that the $1 million definition happened back in 1982, when you adjust for inflation, that $1 million in 1982 comes out to about 2.8 or 2.9 million. So back when we started this definition, that's really what the threshold is. And so it wouldn't surprise me that at some point you come up with, you update your numbers, right? This is 40 years ago. We're going to update it and we're going to make it whatever, something more in line with inflation. And then to me, it makes a ton of sense to have that provision to increase the limits if you're providing at the same time this avenue of becoming accredited through a certification program. So on the one hand, yes, you may have $2 million in net worth. And so you used to be accredited under the old rules, but now it's going to be 3, 5, 10 million, whatever the number is. You're not going to be accredited anymore, but you have this other avenue now that you can go take this exam. So I don't think those two things are opposites. I think it actually makes a ton of sense that those are congruent. And the question then just becomes, number one, are they going to increase the limits? Because again, this is all sort of rumor mill. If you look at the SEC agenda, you look at the SEC, minutes or anything, there's no reference to any of this. There's no reference of a number or even that they're going to be increasing it. What they're going to be doing is coming out with the proposed rule. So I don't know how these rumors started, but I don't know if it's going to be 10 million or 5 million or 3 million, or they're going to keep it the same. But my gut tells me I wouldn't be surprised if they come out with the proposed rule that says we want to update just to keep up the pace with inflation. And that would probably be somewhere around 3 million. So it would not shock me to see a proposed rule come out from the SEC that increases the limits from the current $1 million to the $3 million, maybe 2.5. And again, I think that's just in conjunction with this expansion. And hopefully that by then, before that rule becomes final, we'll have a few certification programs. So somebody who wants to go take the exam, which I think will be very similar to sort of the Series 65 exam, where you don't necessarily have to study. It's sort of a self-study. Because that was one of my questions, like, is this a weekend course that you have to take? Is it a semester? Is it a self-study? I think it's going to be a self-study course. So you just have to sign up for the exam and pass the exam. But I think it does make sense for those two things to happen at the same time. And we were supposed to get a proposed rule in April, the month of April. So here we are. This is recording in the month of May, and shocker, there's no proposed rule. I just actually checked the SEC website right before coming on here just to make sure I wasn't outdated, and they have not released a proposed rule. But literally any day now, I would expect to see a press release first, followed by a proposed rule. And the way those typically work is they come out with a proposed rule, which is pretty comprehensive. It's going to be hundreds of pages. I think the last one that we did with the updated accreditation information was, I think, 600 pages. So it's a long rule. And then what they do is they invite comments from the community. So, anybody who's involved, whether it's lawyers or investors or regulators, whoever, they'll all send in comments, emails saying, yeah, this is a great idea. No, this is terrible. No, it shouldn't be 10. It should be 2. It should be 5. And they'll have like a comment period for about 30 or 60 days. And then at the conclusion of that comment period, they'll gather those out. The staff will go through them. And then generally speaking, probably 6 to 9 months after that comment period closes, they'll come out with a final rule. They don't have to come up with a final rule. There's plenty of great proposed rules that never made it to final. But theoretically, if they're going to go through with this, I would expect it to be maybe 6 to 9 months following the close of the comment period. They will then come out with a final rule. And the final rule may be substantially the same as the proposed rule, or they may take some of that feedback, and maybe the proposed rule wanted to do 5 million, but after all the comments came up, they were convinced that it should be 3, and so whatever. But they'll take those comments under advisement. So if you have a strong feeling about this, and anybody's entitled to write when the proposed rules come out, there'll be a way to send an email or communication to the staff so you can get your things heard. But that's kind of the current state of affairs. It's also sort of my hot take. There's just my opinion. I'm curious to see if I'm going to end up being right or not of where we are today, because obviously it's a big deal. Now, there are some what's the word I'm looking at? There are some accredited investor definitions that are already out there that a lot of people, I think, either aren't aware of or are aware of and are not quite interpreting them correctly. So I wanted to go through those as well, and then I'll open it up to the Q&A as usual. And so if you've got a question specifically about the accredited investors, start putting in the chat, and I'll just go alphabetical here because I don't have my Bethany today. But we'll answer questions about the accredited investors first, and then we'll open it up to any questions whatsoever. And like I said, I've got about 3 questions here, which I may start with as well. But there's other ways, in addition to currently having the Series 65, 82, and Series 7 investment advisory, that makes you an accredited investor. There's also part of the last update was this concept of a knowledgeable employee. So if you're in the business of doing funds, it only works for funds. It doesn't work for project-specific syndications. But if you're doing a fund and you are an employee of that company and you're intricately involved in the investment decisions of that fund, then you are going to be considered an accredited investor now, pursuant to the updated rules from now. I guess it's been about 1.5 years ago now. So that's what's called a knowledgeable employee. Now, you have to have been an employee there for more than 12 months. So you can't just bring in a non-accredited and suddenly make them an employee in order to sort of get around the rule or somehow try and get them accredited when they're not. They've got to be there for 12 months. But on a fund, if somebody's intimately involved in the sort of investment decisions or part of that process, they may be considered an accredited investor. The other one that really has a lot of I think, misunderstanding is one of the ways you can become accredited is if you are the manager, you're either the manager of the syndication, which nobody is, or you're the manager of the manager, which is more likely. So in our world, in the syndication world, you have the company that owns a property, which I call the syndication LLC. I think it's kind of the popular vernacular. Legally speaking, that is the actual issuer of the security, because that's where your investors are coming into. But if you are the manager of the issuer or manager of the syndication LLC, or the manager of the manager, then you are also considered accredited investor for purposes of that syndication. So it's possible, and that's how you become, if you're doing a 506C deal, for example, and you're a sponsor and you're not accredited, that's how you kind of get into that deal and become an investor, even though you're not accredited. It's because you are not only a co-sponsor, but you are a manager. It's not good enough for you just to be a member of the GP entity, if that makes sense. There's really two misunderstandings. One is you have to be the manager or an executive officer, somebody who's actually doing the day-to-day decision-making thing. And number two, it only applies for that particular syndication. If your syndication, if you're doing a fund of funds and your syndication is investing in somebody else's fund, you're not going to cut it for purposes of accreditation, because you have to be the manager or manager of the issuer that's actually issuing the securities. And so if you're investing in another company as a fund of funds, you are not the manager of that underlying entity, you're the manager of yours. So, but being the manager of the issuer is another way of doing it. The other one that comes up, which it came up, I think, in one of the first lives, but if you're a relative, actually, so if you are an accredited investor and you make an investment in the deal, a relative or a spouse of a relative that lives in the same primary residence as you would qualify, technically not an accredited investor, but would be eligible for the investment. So for example, most commonly would be your kids, right? So if your kids, somehow you want to have your kids invest in the deal, your kids obviously are most likely not going to be accredited because they don't have any network or maybe not any income, but because they are a relative of yours that live under the same roof as your primary residence, they would qualify as what we call a purchaser for a 506B deal as one of the sort of accredited investors. So that's another thing that'll pop up. And then the last one that gets a little bit of confusion is this $5 million number, which on the individuals, we know it's the $1 million and the $200,000 annual income. On entities, if the entity itself has $5 million or more in assets, it's considered accredited, but it can't have raised the money to become that 5 million. So it's got $5 million in assets that were not acquired for the sole purpose of in making the investment. Otherwise, you could just raise $5 million and you would be an accredited investor on the LLC. So that's another kind of issue that pops up. But that's kind of where we are right now. I think I'm gonna, hopefully that was helpful as sort of an introductory. I know there's a ton of questions that are going to come through. I'm going to start on my own here because I got a great question from William Makilski, I believe. Did I butcher that? I don't know if you're on or not, but I'm going to read the question because I think it's a good one. And that, oh, there he is. You are on here. So I know you had, William, you asked for a bunch of, why don't you unmute yourself and ask the question that you asked about the different expiration dates of when you're trying to verify an accredited investor and you're getting sort of a CPA verification letter and all that stuff. There's some confusion as to the timing of that. And I thought that was a good question that we can maybe get started with.
Yeah, thanks. I switched computers. Does the audio work?
Yeah, I can hear you just great.
Great. So I was having a conversation with a few real estate investors over the weekend, and there was significant confusion about which third party they would go to, because one had you could be accredited with this organization and you would be 60 days. Another one was 90 days. And some of us had the same accounting firm, and we weren't even sure how long the CPA letter would and so forth. So it's if you become accredited and you have to go every 60 days, because that becomes a bit of a hassle as well. If you're working a deal and the syndication runs over 60 days, you may have to requalify while you're in the middle of processing paperwork. So yes. I wonder if you can get some clarification around that.
Yeah, I thought that was a great question because there's actually a little bit of a change happened last year, which I think maybe is contributing to that. I'm going to just meet you here, which is contributing to the confusion. So whether it's a CPA verification letter or whether it's you reviewing actual financial statements, assets or whatever, the deadline is 3 months. It's 90. I don't know if it's 3 months or 90 days. I'd have to double check that, but let's just call it 3 months. So if you get a CPA verification letter, that letter has to be dated within 90 days. Let's go with 90 days. It needs to be dated within 90 days of the actual purchase of the security, right? And so that's the rule that was there from the beginning, and that's the rule today. So there's no room for interpretation there. So I'm kind of curious to see why one third party would go one way with the other. What's changed, and maybe this is the confusion, is that, as you mentioned, that became kind of onerous, because if you were doing multiple syndications, to have to go back and get a CPA verification letter time and time again, or if they're just looking for financials, you got to ask for the financials again because it's got to be within that 90-day window. It was becoming problematic, and so the SEC actually loosened up the rules a little bit in terms of how often you had to go back to get the verification, and they extended that to 5 years. So the tricky part, though, or maybe the confusion, is the original verification remains exactly the same. So the original verification, you've got to verify within 90 days of that first of your sale of the security. But once you get a proper verification, right, whether it's a CPA verification or financials, then that's good for 5 years. So you don't have to go back a second, a third, a fourth time when you do your next syndication at the end of this year, and another syndication next year, and another syndication in 2025. You don't have to go back. That document you have is good for 5 years. The only thing you need to get from the investor is a written confirmation or affirmation that their accreditation status has not changed. And the way we do it is we actually have a negative consent in our questionnaire. So there's actually a little box so that it says, hey, you check the box and say, since the last time I've been previously accredited or verified as accredited, and my accreditation status has not changed. But if that's not there, you can just get an email. It doesn't have to be anything fancy, an email from them, just some affirmative representation that hasn't changed. But that's the 5-year rule, so you don't have to go back for one. But the initial accreditation is still 90 days, whether it's a CPA verification letter or not. So I don't know if I think that clarifies. I think that's what you're asking about. I don't really know why different verification companies would have different time zones. There's one rule, there's one law. Maybe they're interpreting it wrong, but there's only one law. You had another question. I'll just answer real quickly about, if there was one form that was better than another, right? In terms of I think the question was, is one form of being accredited better or stronger than another? I presume you're talking about the verification, because obviously you're accredited, you're not accredited. The question is, what's stronger from a verification standpoint? I would, even though it sounds like, and I didn't know this, but it sounds like different verification companies have different, it looks like theoretically you could go to one verification company and they say you're accredited, and you go to a different one and say they're not. But I would almost insist that you use one of these third-party verification companies, because what you're doing is you're offloading the risk, the compliance risk, from your side over to that verification company. So if for whatever reason they screwed up, they're going to be giving you, so what's going to happen is they're going to be giving you their own verification letter, right? It's going to most likely going to come from an attorney, but they're going to do their due diligence. They're going to get a CPA verification letter. They're going to do whatever they need to do. And then they're going to give you a representation, and they're going to give you the letter, and you are entitled to reasonably rely on that letter. You've done your due diligence. You've taken reasonable steps to verify by getting that verification from the third-party verification. It's just a really easy way to offload that risk for what, $60, $70, $80. I don't know what the going rate is these days for an accreditation, but it eliminates that risk for you. Why would you take on that compliance risk? Look, we're already kind of nervous. Is this good? Is that not? Is this, like, forget all that. Go with the third-party verification company, get that letter. Once you get that letter in your hand, you can rely on that representation. I don't like CPA verification letters directly, because what's happening is, and this is known from day one, same problem. You're shifting the compliance risk off of your plate onto the plate of the CPA. And the CPA is like, I don't want this compliance. I don't want to take that. I mean, I'm happy to help you, but I don't want to take on all this risk. If it turns out I'm wrong, that you're providing false information, or I didn't do proper verification, now it's they're on the hook, and they've got a license. And so larger CPA firms who have, insurance counsel, a lot of them are not allowing them to sign whatever verification letter I provide them. And so what tends to happen is they start tweaking the letter, right? You send them, I have a CPA verification letter template that if they sign it without changing a comma or changing a letter, that's good. problem is they don't do that. They'll look at it and they'll change the language because they don't like this, or they'll make it weaker, and they'll start messing with the letter. And the minute they start messing with the letter, I'm not comfortable enough with it. So if you use my template or a template from your attorney who's prepared it and they know that template is compliant, if you can DocuSign it to them so they can't change the document they just signed, that's okay. But if they start messing around, again, I would just go back to the third party verification company, have them go get the letter and go argue with them and debate whether the language is appropriate or not. And you can just rely on that representation from the verification company, because that most likely, the ones that I know of, typically are an attorney that'll actually, sign that verification letter. All right. Yeah, thanks, William. Appreciate that. And I got another one there, but I'll answer that a little bit later on here. Let's go. Man, a lot of questions. Let me just go through here. There's a REIT question. Dan, 506B, Dan, you want to answer? You unmute on your VC question?
Sure. Yeah, so I was wondering about the bigger thing is if you know the person you're talking to is accredited, if that actually matters if you don't have a license. But the way I wanted to frame it here is like if the person openly identifies as a venture capitalist or an angel investor, so and it turns out that they are actually accredited, like is there some sort of difference in soliciting them in like the Shark Tank style way where it's like, hey, this is what you do, so this is my business idea? Like, is that suddenly okay that you're like selling that security?
No, in fact, I think it was in the actual rule itself when it came out, whether the investor ended up being accredited or not is immaterial. It doesn't matter. So there's no rolling dice. Hey, I'm pretty sure they're accredited, so I don't need to do all this verification because I know they're accredited. Well, you think you know they're accredited, but if it turns out it's not the end result. It's did you take reasonable steps to verify yes or no? Whether they ended up being correct or not is immaterial according to the SEC. And the other thing you got to be careful about, and I always like to give the example of Donald Trump, because back in whenever it was in the 80s when he was bankrupt, remember? I mean, he was like negative $800 million underwater, negative net worth. Yet he's driving around in limos and living on Park Avenue or whatever. I mean, from the outside, he looks like he's a multi-trillionaire, but in reality, he had so much debt that he was actually technically had a negative net worth. So you may know how much assets they have. They live in they have a huge home and they have all these businesses and whatever, but you don't know what their debts are, what the liabilities are, and so you can't just rely on that. The only thing you can rely on is if it's something that comes from an SEC, like a filing. So for example, if it's a public company, if you're trying, this is maybe not realistic, but if you have Bill Gates, right, or Warren Buffett, who wants to invest in a deal, you can't just be like, oh, he's Warren Buffett, I'm going to go with it. But you can go to filings because they've got filings of you can figure out their net worth from formal filings. So you can rely on filings. But again, we're already discussing whether somebody's just do the third party verification company. You'll get a verification letter from them and go with them. I would not risk, sometimes people come to us with it and it's like, well, here we are. Now you got an attorney at, $10,000 an hour or whatever it is that's now looking at and spending 20 minutes looking at whatever the CPA verification letter. It's just easier. And the most economical way to offload that risk is to give it to a third party verification company and let them have an attorney who's licensed. They either have that in-house or they're hiring an attorney who's going to write you that verification letter, and they're insured, right? They've got a license to protect.
So, but if I pull out the yellow pages and go, angel investor, venture capitalist, if I just show up at their office, hey, I got this business idea, it's my understanding that that's like you're trying to sell a security, and that's not okay unless you've
that's like my Donald Trump example. It's my Donald Trump example. You opened up and you had a meeting with Donald and you pitched him. He's like, oh, I'm sure he's accredited. It turns out he's negative $800 million in debt.
Okay. Oh, you see, you're just still in trouble. Yeah. Awesome. Thanks.
All right, Dan. Good seeing you, buddy. All right. Let's see. Vish, mute. Is it Muni or Mooney? Vish, you want to unmute if you're still on?
Just give me. Yeah, Vish Muni. How are you doing?
Good, Vish. How are you?
I'm doing good. Yeah. So my question is basically I've raised capital only for 506Bs all the time. And this will be the first time I'll be raising capital for 506C. Now, in terms of if I'm going to advertise my deal, is there any specific verbiage or words which I should not be using? And can I take the investors and have them accredited to a third party, or they need to do the verification on their own?
Now, I would definitely use a third-party verification company, but when you're doing a 506C, unlike these other things, it's okay for you to advertise to non-accredited. That's going to happen, right? If you're going to do a radio ad or whatever marketing piece, you're going to catch non-accrediteds in that net. So that's expected. Like if you're on a podcast, obviously you don't know where that's marketing, but all you have to make sure is you don't accept monies from that non-accredited investor until you've gone through the process of taking reasonable steps to verify that they are in fact accredited. The only guidance that I would give you is that if you're doing a 506C, this is kind of one of my pet peeves, but so it's totally fine, legal for you to post things on social media or talk about it on a podcast because you're doing a 506C. I would just take the extra step and just put a little footnote or an asterisk on your Facebook post or your LinkedIn post or whatever, wherever you're posting, that this is a 506C deal and it's for accredited investors only. That way there's nobody that can misinterpret that, or, you know, a regulator or a friend of a regulator gets a hold of this and they start, you know, picking up the phone and calling you. Even though you're in the right, you still don't want to go through that time and headache and expense of dealing with that. So just put that little asterisk on your post or on your podcast and say, hey, this is for accredited investors only and a 506C. And then the other big thing, obviously, not obviously, but you know, you're still always subject to the anti-fraud provisions. And so you want to be super careful about making specific, you know, projections or something like that. I would never say, hey, I've got this investment, we're returning 10% annualized returns and 20% IRRs or something like that. At best, you want to do ranges, and I'm not even sure I'd go that far. What you're trying to do on a post is just get them off the platform, getting to your landing page where you can put a bunch of disclaimers and let them know, hey, this is a 506C, you know, and you can put all the disclaimers, which you can't really do all those disclaimers on a post, which is why it's a little bit tricky to actually get too cute about specific returns. But to the extent you do returns, just put a range. You know, our cash on cash is somewhere between 6 and 12% or 6 and 10. And we're targeting an IRR of, you know, 15 to 20 or something like that. And then get them off there and put them on a landing page or on your website where you can then fully disclaim everything there.
All right, that sounds good. Thank you, Mauricio.
Right. Thanks, Vichy. Appreciate it. People still coming in here. Yeah, Arish, I did talk about that that's kind of exactly what I talked about for the first 15. I know you jumped on late, but the replay will be on the Facebook group and also obviously on YouTube. BD, I think I addressed this, but let me just ask you, you've asked it very succinctly. So BD asks, manager of the fund of fund would qualify as accredited investor based on directing investment decisions. So I kind of, let me just repeat it because I just want to make sure clear. So when you're doing a fund of funds, there's two separate syndications. One is your fund that you're raising money, right? And for purposes of that fund, you would be accredited because you are the manager of that fund or the manager of that fund. So you qualify specifically under Rule 501 because you are the manager of the manager. However, if you're investing in another syndication that requires accredited investors only, then you have to go through the regular process, which is, you know, is your fund accredited? And the way you typically would do that, unless it's got $5 million in assets already, is that every single member in your fund needs to be accredited. And you're not going to be able to rely on that manager of manager because you don't manage the underlying fund. So that manager of manager would only apply to the underlying fund for that purposes. So it gets a little tricky. So if you're not accredited and you're doing a fund of funds, you're going to be limited. Your LLC is going to be non-accredited if you're not accredited for purposes of fund of funds. That's kind of where I'm going on that. All right. Christopher, I have no clue. Christopher asks, how does a Series 22 fit into the accredited mix? I don't know what a Series 22 even is. So just for clarification, I actually had a question about it as well. So even though I put a checklist together about I just wanted to do a step-by-step of how to do get to a Series 65 license. The only reason I'm attacking the Series 65 licensing is for purposes of qualifying. If somebody's interested in qualifying as an accredited investor, I am not a specialist in investment advisory rules. So in terms of, how the license plays into, your advisory firm or registering as an investment advisor or what that looks like, that actually our good buddy, Alex Davies, we usually consult and associate with him when it comes to those kind of issues. So I do not know what a Series 22 fits in other than to say, what I can tell you is that Series 22 is not one of the series that is listed on the accredited investor definition. It's only 7, 82, and 65. The only other accreditation from an investment advisory stuff is if you're an SEC licensed, which you'd have to have over $100 million in assets under management. So if the question is, does a Series 22 count? I would say the answer is no. John, I saw you there, buddy. You want to ask your questions? I know it's a quick one, but let's get you some FaceTime.
John Michaelides.
Yes. Yeah. Hey, John, how you doing?
Good, good. How are you?
Good, man.
Yeah. So talk about sophisticated investor. That's kind of amorphous, and I haven't really seen anything specific. It seems like it's very subjective.
It is very subjective. So a sophisticated investor is generally not an accredited investor.
Mhm.
Although so that's kind of the way you would think about it. Although I would say all accredited investors should be well, actually, that's not true either, because there's a bunch of a lot of dumb accredited investors, for lack of a better word. So they
Well, under the law, forget about reality. Under the law.
So let's talk about it, because it's very clear a sophisticated investor comes under the realm as if you're going to take 30, if you're doing a 506B, you're allowed to take 35 non-accredited investors so long as they're sophisticated. So you have an obligation to make sure that those 35 non-accredited are sophisticated. And the definition of a sophisticated investor, if I can not screw up this definition, is an investor who has the sufficient knowledge and expertise in business and investment matters, financial matters, that they can figure out the merits and the risks of the investment. Do they have sufficient financial and business acumen so that they can figure out the risks and the merits of a particular investment?
Is there any case law? I mean, if someone has a bachelor's degree in business administration, are they sophisticated?
When you're doing when you're establishing your pre-existing relationship, when you're going through those 8 steps that we've talked about, the whole reason you're doing those 8 steps, the whole reason you're sending them a questionnaire, the whole reason you're spending 15, 20 minutes with them once or twice, and maybe a cup of coffee, the whole reason you're going through those 8 steps is to figure out if they are sophisticated or not. So I'm generally not super concerned about the sophistication piece, because they're going to be making representations to you. And so you can reasonably rely on those representations. Plus, if you document that you've gone through those 8 steps and you've asked them the right questions, I mean, can they lie to you? Sure. But you're asking them, what's your investment experience? How have you done syndications before? What's your net worth? What's your level of experience? How long have you been doing this? I mean, all those questions are meant for you to figure out, A, whether they're sophisticated, and they're questions then for them to ask you about what your philosophy is in your sponsorship stuff. So the definition is clear, but whether they actually have the financial or business acumen is going to be a judgment call. So as long as you can prove, which is why it's so important to document all those 8 steps, if you can show that you had the phone calls and you've got notes from the phone calls, here's the questionnaire, here's a copy of the question, here are the emails that went back and forth, here's, whatever, then I'm generally not as concerned about
I'm
that.
thinking about all the educated people that aren't accredited. There's CPAs that aren't accredited. There's lawyers that aren't accredited, right? So
Right.
that's what I'm thinking about. If someone has a law degree, are they automatically?
No, in fact, the SEC specifically, and that, we talked about the comment period when they were coming out with this new expansion of the accredited investor definition. There were people who commented and say, hey, we think CPAs and lawyers, by virtue of their licenses, should be considered accredited. And the SEC came and said, we're not there yet. We're not ready to make that expansion, because that's an assumption. Plenty of lawyers don't know. Think of, there's plenty of lawyers that don't know much about investing, and the same thing with CPAs, right? And so they're not ready to make that jump. Will they do that in the future? Maybe. But as of right now, having a legal license or a CPA license does not make you an accredited investor. I don't think it would make, my personal opinion would be, it doesn't automatically make you sophisticated. But having, you know, a high degree is part of that equation. And that's part of when you're interviewing them, you know, hey, I went through all the schooling. That goes into that equation of whether they have, you know, financial and business acumen. So thanks, John. Appreciate it. That was a good question. All right. That's a good one. David, that's a good one. I'm just going to read it real quick. Do IRA funds count towards accreditation? That's a good question. I don't know the answer to that. It definitely wouldn't be on the income side because you're not, I mean, any income, even if you have a self-directed IRA, any dividends or anything like that, that would all belong to the custodian anyway. Let me get back to you. That's a great question. My gut tells me that it's no, because you're not the owner, right? So they're not your funds. There's a custodian that technically owns them for your benefit. But that's a great question, David. Let me circle back on that. I'll post. If you're not a member of the Facebook community, the real estate syndicator community, I live in there. So I'll answer that question there, David. But nice question. I don't.
Thanks, Mauricio.
Yeah, thanks, David. Hannes, how are you, buddy? Oh, he said, John, those are reserved for. Okay, so you were responding to John there. Evelyn, there's a thing about Series 65. Evelyn Mitchell, you want to ask your question? Sorry, I just muted everyone again. You want to unmute yourself again, Evelyn, if you're here?
Yeah, I think you already answered it though, when you said that you don't really know all the ins and outs of having to get licensed about Series 65.
No, but I do know the answer to your question here just because I went through that checklist. So ask your question because I can definitely answer that specific piece.
Okay, yeah, I was just wondering if you do have to have a firm that is sponsoring you to get licensed in order to become accredited through the Series 65.
Yeah, and that's a similar question than another one that I was going to read. So thanks for reading that one, Evelyn, from Amos Lap. It said it's hard to find an investment firm to hang my name under after I have a Series 65. So the reason why one of the reasons a Series 65 license is easier to obtain than a Series 7 or a Series 82 is that a Series 7 and a Series 82, you need a sponsoring firm. You need to have an investment advisory firm sponsor you. So if you are not in that industry and you just want to become accredited and be the Series 65, that's going to be almost impossible. And so that's why Series 65 is the easiest, not easy, but the easiest because you don't need that. But the challenge is, as Amos was bringing up, is that when you go through that whole process and you take the Series 65 and you pass the Series 60, now you've got that passing of the exam, you now have to go hang your license under an investment advisory firm. And as you can imagine, unless you're going to help them out and make money for them, they have no interest in having you hang their license under their firm just so that you can become accredited, or they're certainly not really that interested, even if you were legitimately trying to use that license for syndication purposes. They don't want you going out and selling your syndication. They want you to sell whatever products they're selling and advising. So it's difficult, not impossible, because I have heard of it. It's difficult to find an investment advisory firm, unless maybe they're a buddy of yours, that will just accept you and you're going to be able to hang their license under their firm because they want you to make money for them. And so what typically happens, and this is why it gets a little bit more expensive and a little bit more complicated, but what generally happens is that you need to create your own investment advisory firm. So set up an LLC, call it the ABC investment firm or whatever, and then first register your investment firm to become an investment advisory firm, and then you can hang your license under your own firm. Gets a little bit trickier. There's a bunch of compliance and stuff that you got to do. So most people in my checklist, they were recommending that you get a consultant or somebody to help you there. Maybe it's an attorney. It wouldn't be me, but some attorney that helps you with it. But that's how you get around that. And that's kind of the answer to Amos's question as well, is that you want to create your own LLC and then register that LLC first as an investment advisory firm. And then you can then hang your license under your own firm.
Okay,
But great question,
thank
Evelyn.
you.
Thank you. No, thank you. Thank you, Dan. David Robbie, this is a question or a comment here. David, you want to ask your question real quick?
Yeah. Hey, so Mauricio, whenever, again, maybe it's been living in California too long, but any legislation has a winner, and it's rarely the taxpayer. And so when I looked at this, I said, hey, who's the winner here? Is there licensing fees involved with this? Is there other things? Is there a way for our good friends in Sacramento? I think you might be in Texas. I can't recall, but
Oh no, I'm in SoCal. I'm down here in San Clemente.
so you're along with me with our friends in Sacramento trying to dream up new ways to generate income. So who's the winner on this?
Yeah, I'll tell
this
you.
change?
Well, yeah. So first of all, this is a federal issue, so not really necessarily the state. Although yes, if you're in California and you pass a Series 65, you're gonna have to hang your license in the state of California. I don't think the licensing fees are crazy. And again, I don't want to be a conspiracy theorist guy, but so what I'll do is I'll channel it through my good friend Russell Gray, because he's out there publicly saying these things too. He would tell you it's Wall Street lobbyists, right? Over the past, since the Jobs Act passed in 2012, the amount of companies that are going public have gone smaller and smaller and smaller, and a lot of people are going private, not only because of this, but also because they've expanded the amount of shareholders or members that you can have before you have to go public. It used to be 500. So once you reached 500 investors, you had to go public. Now it's 2,000. So companies can stay private longer and longer. And obviously, if you've got this avenue of going the private placement route and you can have up to 2,000, why would you go public almost like and be under that scrutiny? And so Wall Street is missing out, is what Russ Gray would tell you. And so obviously with all their lobbyists, they want to make it harder and harder and harder for people to be able to invest in private placements. They want people to invest in public markets for the stock market. So that would be Russ's. That sounds like a good. That sounds like a good explanation. So if you're following the money, and that would be one explanation. But I wouldn't say it's California and Sacramento. It's federal. So I do think it would be more on the side of Wall Street.
Okay, great.
Yeah,
hey, thanks a lot.
Thanks, David. All right, let's keep going here. Michelle's in the house. Hey, Michelle.
Hey, my friend, how are you doing?
I'm doing great. You want to ask your question?
Yeah, so I wanted to know, is there specific language in the CPA verification letter that needs to be in there to meet the SEC guidelines? I know you have your template, and I think you and I had discussed this before, but what I'm experiencing right now is I'm having a lot of investors just tell me, oh, I have my CPA, give me a letter. And I realize
there's specific language. That's sorry to cut you off there. There is specific language that has to be in there, which is why it's in my version. I was just making a note here because what I'll do is similar to what I did last week, and I put the Series 65 in the Facebook group. I'll drop the verification letter, the CPA verification letters, the templates that we have. I'll drop them in the community. So if you're not a member of the community yet, just go to the Real Estate Syndicator community, and I'm there all the time. And it's a great community of people really helping each other out there. But I'll drop in there. But yeah, the answer is yes, which is why at this point, I'm just telling people, like, don't even bother with the CPA. But I mean, maybe not bother. If you send them, you and I are working together. So if you send them my letter and they sign it, they put their letterhead and they sign it, great. You've saved $60. Congratulations, and you can move on to the next one. But if they come back wanting to change something, now you're stuck because now you don't know. So now you're going to go ask me or a lawyer, and it's like, and then you're negotiating. Now you just spent 2 or 3 hours trying to deal with it, when the easiest thing would just be to go through the third-party verification. That they can review the letter and they can say, yeah, that's good. We're willing to issue our letter based on that CPA verification letter. Or no, that's not good enough. Let me send you. I think what they'll do is they'll send their vetted CPA verification letter to the CPA, and either the CPA signs it, and that way they're comfortable and they can check the box, or they don't sign it, which means they're not comfortable. So now you got to go with another method of verification, which is probably going to be, assets or tax returns or something like that.
Yeah, that is probably a better strategy. I think some people are a little antsy about disclosing net worth and all those other things, and they'd rather just have a CPA,
Agreed.
Sign a letter. And
Agreed.
I'm not comfortable with that. So I like that, just sending the letter through the third party and letting them hash it out and de-risk.
Yeah. And if you look at the rule itself, when it came out, there's a footnote that says something to the effect of, the SEC says, look, we acknowledge that there could be some conflicts or whatever, and there's a lot of concerns because at that point you're shifting the risk off of you, which is what you want to do, and you're putting it on the CPA. and the CPA's either not getting paid enough. And my experience has been if they're a sort of a solopreneur or it's a small firm and they want to keep you guys as clients, they're most likely to sign it. But if you're working with a larger firm, they're going to have insurance counsel, and the insurance counsel is going to want to review the letter, and they're going to have their own letter that's been approved by insurance counsel, and they're not going to tweak it. They're going to be like, hey, we can't sign this version. We've got our own version, and that version typically isn't good enough.
Okay,
Yeah.
cool. Thank
All right.
you.
No, thank you, Michelle. Good to see you.
You too.
Anthony Pinto, you want to ask that? I may be able to answer that. I'm not sure. Maybe that gets a little bit out of my wheelhouse. You want to ask your Series 65 question?
Yeah, thanks, Mauricio.
Yeah.
Yeah, I was just looking up the Series 65 stuff on Google really quick. So I know it's state specific. So let's assume that we pass the test in Texas, for example, and then we find someone to kind of hang our license on. So does that mean that we're accredited nationwide, or does that mean we're accredited for the sake of a specific offering in that specific state?
No, you're accredited. It's a federal thing. You'll be accredited. So the requirement is you have to have a Series 65 license in good standing and registered under the investment advisory, but that's going to be a state thing for you. But once you get that license under the state of Texas, in your case, you'll now be considered accredited from a federal standpoint and for all the syndication deals.
Okay, perfect. Thanks.
Yeah, thank you. Thanks, Anthony. Good question there. It's good to see. Oh, it's a lot of questions. I don't think we're going to get to any you have to send them almost. Julie. That's a great question, Julie. I might be out of. Justin, yeah, I'll actually, yeah, Justin, I'm going to put that in the Facebook group. I will make it available. I've got two actually. One is on the income side, and one is on the net worth side. So I'll post that in the group. Going through here. Yeah, William's asking about what's theoretically the income requirement become. Quick math. I mean, there's been no discussion on the income side, but I can't imagine they would increase the net worth on the net worth side and not increase the thing. So I mean, I would, if I'm right, and I don't know that I am, but if they adjusted for inflation and come up with a $3 million number, then you would just do the same for income. I would say maybe $300,000. I'm sorry, $200,000 back in 1982. I can't do the math. I'm tired, but whatever that fraction is, I would just assume it would, I guess it would just triple the same thing, right? It would be probably $600,000 net worth, which I guess would put you in the top freaking 0.5%. So that one, I could see them going to that whatever that magic number for top 1% is, 450 or something. But I'm totally, at this point, as you can tell, I'm just totally, it's total speculation on my part, just kind of my gut feeling. But yeah, who knows, William? Thanks, Hannes there. Yeah, if you guys aren't checking the chat, there's a lot of, everyone's kind of jumping in, which is what I love about the community on the Facebook group too. Everybody's helping each other out. So there's people who are responding. So if you're not checking out the chat, I would do that. I'm going to run out of time here because I do have to, we're going to do a hard stop here at the bottom. Let me see if I can find, let me just actually, I want to make sure I don't miss any of the other questions here. No, I think that was it. That was the main questions there. Amy, great question. I don't know if I'll get to that. If I don't get to your question, obviously you can ask it next week, but drop it in the Facebook community. Like I said, I'm hanging out there all day. So if you guys drop questions there, I'm happy to answer them there as well. Segregated depreciation study. All right, I think we're getting now into the non. If anybody has if you want to just, I think I'm out of the non. Hold on, BD. If there's any other, good. If that's interesting, yeah. BD says if we have received a third-party verification letter that doesn't have an expiration date, how do we treat letter expiration date? That's weird. I mean, a verification letter, it wouldn't have an expiration date. It would just have a date that it's issued. I can't imagine they're issuing letters without a date on the letter, today's date. I would expect it to have today's date. And so that's and I wouldn't even use that date. I would use the date they became an accredited investor into your deal, the first deal, and then I would just go 5 years from that. And again, I wouldn't cut it close either. I mean, if 5 years from now it's a close call, I mean, I would just get another one, but it wouldn't have an expiration date. It would have just the date of the letter, which is what I would use.
Thanks, Mauricio. The reason I asked about expiration date is because sometimes when you go get accredited by an agency, they give you like, this letter is only good up to this particular date. And recently I got a letter from an accreditation agency and it didn't have a dead end date. And I had to kind of enter in the fund information that, you know, they ask you is like, how long is this investor accreditation letter valid until? And
Yeah, 90 days. So it's going to be 90 days from that. Or, and again, I'm not 100% sure if I think it's 90 days, but it's 90 days or 3 months. There might be a slight difference there, but I think it's 90 days actually, not 3 months. But it's 90 days from the date of that letter, because that letter is as of this date is when they've done their due diligence. So it's 90 days from the date that the letter is issued.
thank you.
All right. Any other questions specific to, if you just unmute yourself, if you've got a question specific to accredited investor that I somehow missed on here. If not, I'll go through a couple of questions that are generic. All right, so let me just go back to the top here. Evelyn, Dan, David, we got all these. Everything accredited. Julie Boyd. Oh, this kind of has in light of new regulation. Maybe I missed that. Julie, you want to ask your question? Julie asks, oh no, she's.
Oh, I'm unmuting. There we go.
Hey, Julie, how are you?
Mauricio, I really appreciate. Hey, so, you know, I work with a lot of ultra high net worth clients and try to get them more in the mode of doing advanced tax planning rather than the seasonal panicked rush to offset a monster tax bill. And so I've been trying to get a lot of my clients, you know, really with our multifamily investments and stuff that I do with them to really look strongly at segregated depreciation studies when it makes sense. And so, you know, obviously these particular clients, you know, that I'm thinking of, you know, I just saved them $700,000 this week. It was a nice week.
Nice work.
But you know, it's going to zero out their actual income or W-2 income, but they certainly have the remainder is ample, but that's not going to be the case for everyone. So I guess my question is kind of like when you're doing financing and applying for a loan, there's certain add backs, right, that you use. So are they, you know, if you have somebody who's averaging 380 to 570 a year, but they zero it out because of a cost seg study, did they knock themselves out of the game?
No, I mean, but I'm with you. I see what you're saying. I mean, especially with lenders, that's also an issue, right? Like if you're trying to get a loan and you're showing from your tax thing. No, it's going to be your income. It's not necessarily what you may struggle with. I think I'm not sure you'll be able to use the sort of the tax form as the proof. You may want to get a CPA verification letter, but that's going to be your income. I mean, if I make $1 million a year in income, right, and I just happen to make investments so that on my tax form I basically show as a loss or zero out, that you're still going to be considered an accredited investor. There's no way that's going to you know, reduce that, because that most of us do that, right? Most of us end up using tax strategies to reduce our income through, you know, the bonus. I mean, the bonus depreciation is the main one, right? Our bonus depreciation reduces our income. Yeah, I mean, I'm heavily into oil and gas, and almost all wipes out all of my income. So, but that doesn't mean I'm not going to credit it, because my income is, you know, I can still, because what I can show, let me give an example. You know, if you're a high income earner, you know, you can show a W-2, right? Your W-2 or your 1099 may all add up to, you know, multiple. There's no deduction going to be in that W-2, right? So you could just rely on that document as opposed to relying on the
1099 alone.
Yeah, my 1099 is from the income standpoint, I would rely on the 1099 or the W-2. Yeah. That's
beautiful.
Exactly what I would
That's
do.
really great. And then I
Yeah.
had a second question in there, which may or may not be in your wheelhouse, but I was having a conversation with someone earlier today, and I'm awful good at, you know, like combining forward and reverse exchanges and all of that. But he had mentioned, you know, when you run out of time or timelines, that you could always exchange into a syndication as a TIC to kind of still then meet the exchange rules. But then what if they are not considered then to be accredited? So how would that play out? How would you structure a deal that would work for somebody who's in a 1031 pinch?
You can definitely, we talked about it at one of the lives previously, but
Sorry.
no, that's good. No, I like to, I mean, not everybody's watching every single live, and these get long, but you can definitely 1031 into a syndication. It just doesn't go into the LLC, right? Because it has to be a like-kind exchange. So if you've got three let's just say, let's say a typical structure, if you've got a tick, let's say you have the property is owned by an LLC and there's three members to that LLC. So the LLC owns the property. That LLC can 1031 into a different property. It can 1031 into a syndication, except it can't be a Class A member of that syndication because that's not going to be a like-kind exchange. It has to actually own whatever percentage it's going to own, direct title into the new syndication deal. So what the end result is the tick entity may own 15% of the property, and then the syndication LLC owns the other 85%. That's how you structure it. Now, there's a ton of limitations on the tax side and how you can distribute, how much you can't take carried interest on the 15%. There's a lot of restrictions that I can't remember what, if somebody wants to put in the chat, what episode that was, but we did a little bit of a deep dive on TICs and 1031s because a lot of people are doing them. And what people are missing is, from my perspective, from a structural perspective, that's easy there's no securities issues for me. I can structure it. Boom. We just, the new property, we just make sure that there's, this tick member owns 15%. The syndication LLC owns the other 85%. We tie it together with a joint venture, a TIC agreement, and we're good on my end from a security standpoint. Where you're not good is on the tax side, because the IRS, it's IRS regs, I want to say 2002-20 or 2020-22, one of those, they have a limitation. There's 15 things on there, 15 limitations, of which about 6 or 7 of them are relevant to us. But the big one is that you must distribute the cash flow from the new syndication proportionally. So if the TIC owns 15%, you've got to pay them the 15% of the whatever the net cash flow is available, and then the 85 will go to the syndication LLC. You can't do a pref. You can't take a carried interest where you're saying, well, even though you own 15, I'm only going to pay you 10, or I'm going to give you an 8% pref and an 80-20. It's got to be proportional. You have to distribute the monies proportionally. Yes, you can take a reasonable asset management fee that's paid proportionally by both parties, or you could take acquisition fees. But there's a bunch of these limitations that, if you go back and see one of the lives, we go through all those 15, not all 15, and we go through the 7 or whatever that are most relevant to real estate syndicators.
Oh, great answer. Thank you so much.
Yeah, no, thank you. I think somebody may have done that. So anyway, we're out of time. I apologize if we didn't get to your questions. I would highly, as more and more people are coming on these, so you can submit questions ahead of time. I'll always give priority to those. And if you submit a question on the Facebook group, I'll definitely give priority there as well. So if you haven't joined the Facebook group, I would highly, yes, Michelle, I'm going to make you get on Facebook. I realize some people are not on Facebook, but the real estate syndication community Facebook, I'm there all the time, and looking forward to the next one. And I really appreciate you guys spending a Wednesday evening with me. I really always humbled that you guys show up. So appreciate you, and we'll see you next week. Thank you.